May proceed.
May it please the court, my name is Jonathan Harwell. I'm here on behalf of the petitioner appellate, Jonathan Cooper. I'd like to talk about three claims this morning. First, most significantly perhaps, the ineffective assistance of counsel claim relating to Rule 412. Secondly, hopefully briefly, I would like to talk about the venue issue. And third and finally, I'd like to talk about the Brady issue. To begin with the IAC claim relating to Rule 412, or what I've sometimes called the Tyler issue, I would frame it by pointing out what I think are two unusual facts. This court, I know from reading the decisions, deals with a flood of post-conviction appeals. This case is different. And it's different for a number of reasons. The first two, it's different because here we have the trial court and the state on appeal conceding or finding that there was deficient performance.
But with respect to one issue.
With respect to the 412 Tyler issue. It's different, too, in that this was undoubtedly a close case to the jury. And I say that not as in a personal assessment of the weight of the evidence. I say that because of the jury verdict. The complainant made two unequivocal sets of allegations against Mr. Cooper at different locations. The jury, for whatever reason, compromise or a close assessment of the evidence, the jury found him not guilty as to one set and guilty as to the other. So this is a case that clearly the jury had doubts as to the complainant's credibility and as to the nature of the evidence. So I want to turn specifically to the 412 Tyler issue. And I would frame that by saying something the trial counsel said at the post-conviction hearing, which is when you have a child complainant accusing someone, or really when you have any complainant accusing someone, you have a question of why. Why would they make this up? And trial counsel said very believably, if you want to call someone a liar, you have to give a reason why they're lying. That was a question that was raised by the trial. It was a question that as the trial happened, the defense did not have any real answer to. The third thing about this case that is unusual is I am not here in the context of ineffective assistance of counsel claim, doing second guessing, hindsight, Monday morning quarterbacking. I'm not saying as to this issue, well, this is what trial counsel's plan should have been. This was trial counsel's plan. He just messed it up. It was absolutely his plan as he testified at the post-conviction hearing. It was his plan to argue to the jury based on evidence that he introduced that the reason they were there, the reason that the complainant made the allegation that started all of this was because she had been found to be engaging in sexual activity with her stepbrother, that she had done the thing that we all know children do when they are in trouble, of making another accusation against someone else. I have children, that happens all the time.
Mr. Harwell, can you help me with something? Because as I read the briefs, in some parts it seemed as though the victim in this case was being perped on by the stepbrother, and in other areas I read it seemed that it was more of a, I can't say consensual, but voluntary contact between the two. What is the appellant's reading of her disclosure as to that?
I believe what the record on this, which would really just be the content of the forensic interview that was introduced, she was asked whose idea was this, and she said it was both of our ideas. So she did not present it in the context of the brother doing something to her. She presented it in the context of them doing something together. It's also significant that in that forensic interview, she indicates they were both punished. So the mother and stepfather didn't say, oh, he did something wrong to you, we'll protect you. It was both of them being punished by being grounded.
I just wanted to clarify that, as it may fall into a prejudice analysis under 412.
Yes, I think the record indicates that it was, again, consensual is not the right word, but it was both of their ideas. And trial counsel's plan was to be able to argue to the jury that she had heat on her because of her mother and stepfather had discovered this, and that she chose to do what children do of pointing the finger at someone else. She was in trouble for a sexual activity, so it made entirely made sense that she would take the heat off of herself by painting herself as a victim of a sexual act. She was talking to her mother and to her stepfather. It would entirely make sense that she would point the finger at the father, not the ex-husband, because they'd never been married, but the estranged father.
How does that entirely make sense, that she would point the finger at all people of her biological father?
I think given the context of who she was talking to, and the fact that he was at a different location, and so mother and stepfather would know that she would go and be with him for weekends, and mother and father certainly can infer we're not on great terms. So is it the absolute perfect story that?
Yeah, why not next door neighbor, gym teacher? We're talking about her father here. And the reason I bring that up is because I'm contrasting it with I believe you pronounce this J-Lo, the case from Colorado that's referenced in the comments to the rule. There you had a situation where the defendant had learned of sexual behavior that the victim had allegedly engaged in and was threatening to tell her parents about it. And the defense theory was that she retaliated against the defendant by making up this story about him. That makes sense in that context. She would have an active reason under that theory to directly target the defendant in that case with what the defense says was a false accusation. Here, it seems like we're a step removed. Other than the fact that mother and father were estranged and there potentially might have been tension there, isn't that a step, a bridge that to assume that she would automatically accuse her father of these things?
I think it's a distinction for sure. But again, we're talking about the mind of a child, and a child who is under the stress of being punished for what was perceived by her mother and stepfather as sexual misconduct. And she does something to take the heat off of her. Can we explain exactly why she said it was Jonathan Cooper? Can we say exactly why she picked the form of that? Maybe not, but I don't think we have to. The point is that gives an explanation of why would this child make a false allegation? Because otherwise there's no reason in the case for her to say something, to accuse anybody of something that was not true.
But doesn't that distinction affect the probative value under that theory as you're conducting the balancing test under 412?
Yes, it lessens it. I'm not disputing that. But given the centrality of this question of, if we're going to call someone a liar, we have to have a reason why she's lying. Given the close nature of the case, even if it does not a absolutely perfect on all fours allegation that would have answered every possible question, the jury certainly could have believed, hey, this gives us some reason to think, actually, maybe she might have a reason to make something up. And that, in the context of this case, any kind of reason to doubt her credibility could have tipped the scale because they already had reasons to doubt.
But do you even get to that point? Is it even admissible under 412 given the lessened nature of its probative value? And we also have to consider the prejudicial effect. to this child that it would have had in front of the jury. The judge would have had to have made that determination before admitting it. We're talking about a 9 or a 10-year-old girl engaging in quote-unquote voluntary sexual activity with a stepbrother. That would be prejudicial towards the victim in a way that could distract the jury from the key issue at trial. So do we even get to the point where it is admissible under that theory, under 412?
I think so, and maybe I'm just seeing this differently. I am saying that it is a lessened value, but it is lessened from overwhelmingly, incredibly exculpatory to just very strongly exculpatory.
Let me piggyback on that question a little bit, if I could, because I think it's an important question. The state has conceded that there is deficient performance here. So if we go by the concessions, then we're essentially just looking at the impact on the trial of the deficient performance. We're not bound by the concession. In most circumstances here where we have evidence being admitted or evidence being excluded, we have to show that either the objection would have been granted, that the motion would have been granted. So had a Rule 12 motion been filed here, what proof is there that the trial court would have granted the motion? More specifically, so I'm looking at the grounds for Rule 412, the circumstances under which they could be admitted. It's not an issue of consent here. Evidence would be required to be by the Constitution, but that could only happen if the evidence has sufficient indicia of reliability. It could be offered for credibility of the victim, provided that the prosecutor has first presented evidence of sexual behavior. How does this fall into the Rule 12 issue? So I can get past this issue in my mind and then get to where you are.
So it falls under 412, I think, under the constitutional argument, which is essentially the argument I've been making here.
So how is there sufficient indicia of reliability?
It is her forensic interview. I don't think the state has ever raised any suggestion that this is not conduct that happened. And the state has stipulated that that's what she would have said happened. The other 412 prong goes to sexual knowledge, and that's another issue, and particularly the trial judge said he would have let it in on sexual knowledge, which is, again, you have a child who goes to, makes an allegation, ultimately testifies about sexual activity, and as defense counsel said at the post-conviction hearing, regardless of how the state argues it, the jury is always going to have in their head the question of, if this didn't happen to her, how does she know so much about sex?
Would that have been an effective argument, though? And the reason I ask that, and I apologize for the graphic language, but this is a graphic case. As I understand her disclosure regarding her stepbrother, it involved, for lack of a better term, genital fondling, fellatio, but no cunnilingus, no intercourse. Whereas her disclosure involving the defendant involved the two latter forms that I just mentioned. So this might explain some of her sexual knowledge, but not all of it as it relates to her allegation of the defendant. And again, doesn't that greatly lower the probative value of it when we're talking about the knowledge of a 9 or a 10-year-old girl?
So there are some differences. She does not directly, in the forensic interview, say that there was intercourse with her brother. She does say at some point it was the same things that happened with my dad. So her forensic interview as to the actions with the stepbrother are shorter and less descriptive. But it still would go to the question of, how does she know about sex? How does she know about which parts to touch? How does she know? I mean, she graphically describes what her brother would do with his hands, what would come out, all of those things that the jury could conclude that she's using that knowledge at least as a substantial basis for the allegation she's making against her father.
Didn't she disclose, though, that the abuse from the defendant predated, at least in some part, her interactions with her stepbrother? And if so, and this is getting a couple steps down the road, we're assuming it gets admitted, we're assuming it's being argued to the jury in the manner that you just described, wouldn't the state come in and say, this doesn't explain her sexual knowledge, all it shows is that she started acting out sexually after she had been abused by her father, and that, in fact, is the source of her sexual knowledge. Doesn't that hurt any prejudice arguments that you might be making on that point?
I don't know if there's really an adequate record that they've established that they could make that argument. Your Honor is right. Her allegation is this happened with my father, then this happened with my brother, and I'm now reporting it. But the important thing is not when she says they happened. It's our contention the one with the father never happened at all. The important thing is she confesses to the issue with her stepbrother first. Then when she's under the pressure from her mother and stepfather is when she makes the allegation against her father. I said I would be brief on venue. I want to be even briefer than I plan to be. We have an agreement, I think, as to what the issue is. It is clear that the state did not ask the complainant whether the apartment was in Knox County, didn't ask the complainant's mother if the apartment was in Knox County, only asked the investigator one question, and did all of these events take place here in Knox County, which he said yes, they did. It's not our contention that the investigator couldn't have testified that the apartment was in Knox County. It is our contention, though, the investigator was on the stand for the purpose of explaining his investigation. He asked, what did you first do? What did you do next? What did you do next? What did you do next? And did all of these events happen in Knox County? I am sure the prosecutor thought he was establishing venue. Obviously, defense counsel kind of assumed that's the magic question for venue. But in the context, that question actually doesn't establish venue. It establishes that the things the investigator had done were in Knox County. That meant after he gets the transcripts, after he reads this, appellate counsel, who was the same as trial counsel, had a winner to obtain a new trial had he raised it for the first time on appeal. Finally,
you raised it as an ineffective assistance of counsel issue and as a standalone issue. Do you concede that the standalone issue is waived under the Procedure Act for failure to having raised?
I put it in there because I couldn't find a case saying it wasn't, that you couldn't raise it. I think logically it probably is not viable as a standalone claim at this point.
It seems to me that we would be analyzing that through the lens of the Sixth Amendment.
I think that's that's the argument I focus on is appellate counsel should have raised it for the first time on appeal.
Okay. And the argument here is, I think you've stated, is it's prejudicial because it would result in a new trial.
Yes.
Okay.
The final issue I want to talk about, and I've, even with more time, I've still frittered it away. The final issue is the Brady claim. And this is an issue where we have a direct request from defense counsel for reports and examinations. We have, perhaps unusually, a response by the state that it is not aware of any. We have a trial where this did not come out. We have post-conviction proceeding in which it was determined that in the prosecutor's file was a record of a forensic examination of the complainant made relatively soon after she made the allegation, indicating that there were no injuries to her hymen. So we don't have really a dispute as to those facts. The only dispute is to materiality. And I don't have a really sophisticated way to argue this other than what I believe I know and what I hope that I am right in assuming you would agree with, which is regardless of what a nurse might say, you have a jury of 12 people from East Tennessee who find out that a complainant's hymen had not been ruptured. There is a reasonable probability that one or more of them is going to believe that is exculpatory, that is something that certainly in the context of this case could contribute to the already considerable doubt that they had about the complainant's story.
Wouldn't they have to rely upon facts and knowledge outside of the record in order to reach that conclusion? I mean, it seems that if this report had been presented, they would have been limited to considering what was in this report, which was the nurse's opinion that the physical examination was consistent with.
I think I see that differently. I agree the report has two parts. It has the factual part, which is the exculpatory part. It has the opinion part from the nurse. Obviously, this wasn't fleshed out in terms of putting the nurse on and calling other experts. But I believe that, one thing we tell the juries, judges tell the juries, is they're allowed to bring their experience into the courtroom. And I believe this is part of our common sense, shared culture. There are people that believe that.
Is it? I mean, maybe in our line of work where we're exposed to unsavory things like this from time to time, but that also seems like it would involve pretty specialized medical knowledge to reach that conclusion.
I certainly have seen...
it's arguable. I see what you're saying, but can you agree a little bit with what I'm saying?
I've certainly heard of many times of people believing, correctly or incorrectly, that one way to find out whether intercourse has ever happened is to examine a child's hymen. And it's not necessarily because they've had some special training. That's what they probably learned from their parents and their grandparents. And I think there's absolutely a chance that one or more of the jurors would have had that belief. The other thing I want to say quickly before I sit down is I think the case law says that kind of argument needs to be approached with a degree of skepticism here for a particular reason. We are not talking about something that was just in the prosecutor's file and they thought about it carefully and decided, I don't think that's really exculpatory, I'm not going to give it over. This is something that was covered by a defense request and the state falsely said they didn't have it. Right? And what the Supreme Court said in Agers was that if there is a request that's not followed through on, we seldom, if ever, excusable by saying, well, it didn't ever matter. So if the state believed that wasn't material and exculpatory, it could write back and say, we have some stuff, but we don't believe we're required to give it to you, and you can seek a court order. It could do lots of things, but it can't say it doesn't exist and hope it never gets found, and when it does get found, say, well, it wouldn't have mattered. And I'll reserve the rest of my time for rebuttal.
General. Good morning, Your Honors, and may it please the Court. Ronald Coleman on behalf of the state. This Court should affirm the post-conviction court's denial of relief. Unless this Court has questions about the petitioner's ineffective assistance of counsel claim related to the closing arguments or his cumulative error claim or his denial of continuance claim, the state will rely on its brief as the petitioner has today. I'll address the issues that have been raised in the same order that the petitioner brought them. And first, trial counsel was not ineffective for failing to file this Rule 412 motion. And Judge Greenholz, as you pointed out, this court's not bound by a concession of deficiency. And I want to be clear about what the state's agreement as to what deficiency was. And so Rule 412 requires you to file a pretrial motion and state what facts you want to present and the purpose for which you want those facts to come in. And so counsel was not deficient. The petitioner raises, I believe, 5 different purposes in his brief as to why he thinks that information should have come in, of these allegations that the victim and her stepbrother had certain sexual incidents. Most of those are not admissible under Rule 412. So for those purposes, counsel wasn't even deficient here. I think where my friend across the aisle and I agree is that at least with regards to some sexual knowledge, this would be admissible under Rule 412 had counsel filed a Rule 412 pretrial motion.
Is it because the evidence would be required to be admitted by the constitutions?
I don't think so here.
Okay.
And really the the petitioner relies on this State versus Jallo, J-Lo, however you pronounce it, this Oregon case. And I think that is distinct. With that case and what our Supreme Court held in Brown is that in certain situations, the sort of constitutional rights can trump mere evidentiary rules. But that's not what we have here. And I noticed that the petitioner repeatedly said today that, he didn't really have, quote, any answer, that it would have been great to present, quote, some reason to the jury, and that any kind of reason as to why this victim made these allegations. Well, that happened here. And I think it's very important to note that was a defense here. Trial counsel at trial did not immediately go straight into opening argument or opening statements saying, like, here's why she did it, focusing on this interaction with TL, with the stepbrother. Instead, that doesn't even come out until we start getting through evidence, and they try to bring it out while attempting to impeach the victim here. So that was only part and parcel of, or that was only a portion of the defense, and the defense that was presented to the jury when that portion was excluded was she had a reason. The petitioner here had divorced her mother, had gotten remarried, had a new child, had moved out, and was now living in his own separate apartment, and that the victim in this case, according to the defense, was seeking attention. The victim felt like she was being left out and wanted to bring attention, made this allegation, and by the time things got serious, she was in too deep. That was the defense that was presented to the trial, to the jury. And so the state would submit that there was no constitutional sort of thing that would trump Rule 412. So the only reason this could come in is to prove some knowledge of sexual matters. And to the extent that trial counsel was deficient for failing to file a pretrial motion with that, I think Judge Hickson, you sort of hit the hammer or the nail on the head, which is that it didn't cover everything. I think you said that there was no allegation of fellatio or oral sex. There was one instance where FC detailed an instance of fellatio with TL. So that is there, but certainly there was no...
Not cunnilingus or intercourse. I think that was the distinction that I saw.
There was... My understanding is FC doesn't allege that TL performed cunnilingus on her,
right,
or that there was any sexual intercourse at all. So I just want to make sure that was clear. But because those instances were never discussed, and that wasn't something that TL was ever alleged to have done, this wouldn't have much probative value to the jury. And it's a jury that very clearly considered the facts and really did a good balancing test.
Well, are you saying... So you're saying that this would have been admissible under 412, under the sexual knowledge part of the statute or the rule?
I think to a certain extent, yes. It does establish...
It's admissible or it's not. So, I mean, would it have been admissible? Would the probative value of this sexual knowledge that we've discussed, given its differing nature from what she says happened with the defendant or the petitioner, would the probative value still outweigh the prejudicial effect?
The state's happy to argue that no, that the prejudice would outweigh the probative value, but I think we are a little constrained here because the post-conviction court found that it would have admitted it for these purposes, at least for sexual knowledge, and so we're sort of relying on that. I don't know if this court's bound by that, but
kind of hard to see how we wouldn't be, though, right? I mean, if petitioner has to show the court would have granted the motion, and the court says I would have granted the motion.
And I think that's fair. And I don't think this court really needs to get into sort of a disagreement with the post-conviction court on that, because even if it had come in, there's no reasonable probability that it would have changed the outcome of trial, because it's
why not in a case of this nature? It's not a he said, she said, but it also does lack some of the other corroborative evidence that we would often see or sometimes see in a child sex case. So how can we say that it wouldn't have had an effect on the outcome, or at least objectively draw that into question?
And I think it's because, as you pointed out,
maybe throwing on one more point onto Judge Hickson's question, you have an acquittal here. So it's not a situation where the jury's returning guilty as charged on all counts, crediting all the state's evidence. It clearly didn't credit some of its evidence. So going back to Judge Hickson's point, help us understand the credibility issue.
And so I think it's important to note why there was that acquittal. And the petitioner here had put on a significant proof at trial about sort of the layout of these different apartments and different things like that. But it didn't necessarily go to that the victim was lying, more that she was sort of confused or didn't really got different placements.
That she was not credible. Credibility, it doesn't necessarily mean an intent to deceive. It could be that I've simply misobserved or misunderstood.
Certainly, but that wouldn't be the same type of credibility that this information would have gone to. So it wouldn't have sort of compounded on that, and it wouldn't have changed the jury's decision, because even if it came in to explain, well, here's how the victim knew about these particular instances, it doesn't explain, well, here's how she knew about cunnilingus, and here's how she knew about sexual intercourse. And even it would actually almost be detrimental to the defense, because in her what all the parties agree she would have said is that these things happened, sort of the same thing that happened with her dad, and that the victim did things with TL, quote, like I did my dad. And so it would almost corroborate her allegations rather than detract from them.
How helpful it is to my defense. My defense is that this victim was saying these things because of the fact that the father had with her. And so by introducing the fact that she had some sort of relationship with her stepbrother, and that it occurred after, and since perhaps could be acting out based upon what she had learned from her father, would that be helpful?
I don't think it would. I think you and Judge Hickson both pointed that out, that it would almost hurt the defense because it would bolster the fact that she was acting out after these.
So for purposes of, so 412 should have been deficient not to file the 412, then even after you did it, would it have been deficient for the lawyer then not to address it during the trial? After you've heard it, you could make that decision. I'm not sure this is going to help us.
I think it certainly could be a matter of strategy of, even if I can get this in, I'm not going to. I think, again, here we are sort of bound. The post-conviction court accredited trial counsel, and trial counsel said, I wanted to bring it out. So to the extent it would have come in, I think we sort of have to assume that it would have at least been introduced by the defense at trial. But we're here really looking at the prejudice here, and the petitioner cannot meet his burden of establishing prejudice. As your honors have pointed out, it almost bolsters the state's argument and weakens the defense's argument. It would actually, had it been presented to the jury, it would sort of be in conflict with this. The victim wants attention on herself. She feels abandoned. She's trying to bring attention to her, but she's also at the same time pushing attention away, and she doesn't want the attention. The jury could easily see this as sort of a shotgun or kitchen sink approach, as desperation. So to the extent that counsel was deficient, specifically for not moving to admit this for purposes of sexual knowledge, there certainly is no prejudice.
Let me ask you this, since I didn't fully understand the scope of your concession on the deficiency point. If it had come in for sexual knowledge, what is your contention as to how the defense could have handled that in its questioning and in its argument? Would their argument have been limited to a sexual knowledge argument? And are you saying that they could not have used that evidence at trial for any of the other 4 avenues that they're proffering here on appeal?
Yes, Your Honor. And so we're looking at whether counsel was deficient for failing to file a pretrial Rule 412 motion, which is required under the rule. That rule mandates that when you file it, you specify what specific actions or acts that you want to bring out and the purpose for which you want to use them. So the court, had it admitted it, and the post-conviction court said, I would have found this admissible for purposes of sexual knowledge. So that's all the petitioner could have brought it in for. That's anything beyond that would have been impermissible. and likely the court would have given a limiting instruction to the jury.
So I know you're not conceding deficiency as it relates to the victim's motive to lie and how this could have played into that. But what is your response to the appellant's argument that it would have been admissible under 412 for that purpose?
I don't think it would have, because the only way that the motive to lie is not a basis under 412. So what he attempts to do by citing to Jallo or JLo is to incorporate it as a constitutional right. So 412 says this can come in if it's a constitutional issue, and in Jallo that was the right to present a defense. And as Your Honor pointed out, that was the only defense presented was, here's what happened. The defendant in that case caught the victim and threatened to report her to her parents, and she said, no, here's why she made those allegations against the defendant. But here we have a defense. We have that she wanted to get attention, she was feeling abandoned, she was feeling left out, and so the defendant was able to present a defense. And as I mentioned earlier, this didn't come out, straight out the gate in opening statements where, hey, here's why she did it. Here's, she made these allegations because she got caught with her stepbrother. That wasn't an opening statement. This was not critical to the defense. And that is what it would have to take to implicate the right to present a defense, to implicate the constitutional issue, which would make it admissible under 412. That's not the case here.
So, General, let me ask you on the venue issue. A lot of times in post-conviction cases, we come down to the issue of prejudice. We either don't address deficient performance or maybe it's clearly there. So we analyze prejudice. On the venue issue, prejudice seems to be there if deficient performance is there. So as I understand the argument from your friend, the investigator is not talking about any events that actually happened at the apartments. Perhaps venues established at the Cecil Road place, but maybe not at the apartments themselves. Help me understand how counsel is not acting deficiently by either believing that venue had been established reasonably or that venue in fact had been established with respect.
And I think that's because venue had been established. And I wanted you to ask the question that whether this was waived as a standalone claim, and it certainly is. This could have been presented, the lack of venue could have been presented on direct appeal.
I'm looking at it through a Sixth Amendment lens. So how trial counsel reasonably could have believed that venue had been established or how in fact it was established.
Yes, and so under that scope of ineffective assistance of counsel, here what the investigator testified to was that he had observed the victim's allegations during her forensic interview and what she discussed happening at both of the locations, both apartments, and that he had reached out to both apartments, he had done other things like that, and then the state asked, did these events happen within Knox County? And he said yes. So the state submits that venue was established, and it's important to note that venue only needs to be established by a preponderance of the evidence, since it's a much lower bar than beyond any reasonable doubt. And here, the jury could infer that when the investigator is saying she said these things happened at these places, and yes, all these events, everything I've told you has happened in Knox County, the jury could find by a preponderance of the evidence, at the minimum, that venue had been established, that these events, that including the allegations that he heard the victim make, had happened in Knox County. And
this was a Knoxville city officer? County. It's okay.
It was either a police investigator or a sheriff's deputy. But yes, it was someone affiliated with at least Knox County, if not the city of Knoxville.
So, but in the record, though, didn't they ask the investigator about Cecil Road specifically? They said that the Cecil Road address, is that in Knox County? The investigator says yes. But there was no question with respect to the apartments, right?
I think that was the victim. They asked, the victim said this happened at, I think Cecil Road is the ones where the acquittals came through, and they asked her there, was that apartment building in Knox County? And for some unknown reason, they did not ask her when she began to talk about this Cumberland, the other apartment. Yeah.
Country Oaks. Country
Oaks, I believe. They did not ask her, was that apartment? But they asked the investigator, not specifically were either of these apartments in Knox County. Instead, the investigator talked about his entire investigation and what he had heard.
And so the investigator's knowledge is coming from the forensic interview?
Of the allegations, yes.
About where things happened?
And I don't think the investigator has to physically go to the apartment complex.
I'm not suggesting that. I'm just trying to figure out the basis.
That's my understanding is, to the extent the investigator's knowledge of where these events took place was from the victim's allegations in the forensic interview.
But from reading the appellant's brief, they're saying if that's what you're hanging your hat on for venue, this witness, this investigator is incompetent to provide that particular testimony. What's your response to that? Because he wasn't there when it happened. What's your response to that?
I would disagree. An investigator is allowed to testify as to whether an apartment is within the county lines. And so really, my understanding of the petitioner's allegation or complaint is that the investigator didn't really specify like these apartments are in Knox County, and instead talked more about here's what I did. And so when he says here's what I did and everything I did is within Knox County, that doesn't establish what happened took place in Knox County. The state's response to that is what the investigator said was, I heard the victim testify about these allegations took place at these places, and then I continued to investigate and did these other things, and all these events took place in Knox County. And when you're looking at whether venue was established by a preponderance of the evidence, a jury could find that that testimony meant that the actual incidents occurred in Knox County. And I think it's important to note that the venue, there is venue here. There's no question that this apartment isn't actually in Knoxville. So we're looking at sort of form over function.
Are you asking a state judicial notice of the fact?
I don't think even the petitioner is disagreeing with it. I think his only allegation is that this wasn't testified to at trial, and the state's submission is that it was.
But outside the proof in the trial record, there's no proof in the PC record that this apartment complex either is or isn't in Knox County.
Not to my recollection. I don't think that the petitioner put on proof that this was not in Knox County.
I mean, that would be pretty compelling proof, I would think.
I think if the petitioner had established that these apartments were not in Knox County, we would be making a much different argument.
And just to close the loop on this, there's no evidence by way of exhibits of any maps or anything like that that the jury could have considered?
Certainly not in the post-conviction.
The trial jury.
The record would speak more accurately than I can. I'm just not sure.
Do you agree that, assuming just for sake of argument, that there was deficient performance in failing that prejudice is established?
No, Your Honor. Again, the state submits that venue was established, so there's no prejudice.
I know that. I'm saying, assume for sake of the question that there is deficient performance here because defense counsel did not object to venue. Let's just assume that for sake of the question. Do you agree that prejudice has been met since the only remedy was trial?
No, and I think it's because it's not that trial counsel should have objected or should not have. Even if this court thinks that counsel should have objected, state's position is that objection would have been overruled because venue was established by this officer's testimony.
Let's assume for sake of, how about this? Let's assume that we meet the first prong of Strickland, that it's all met, just for sake of argument. Do you agree that prejudice would be present?
No, but I want to, the agreement that I think, I want to make sure we're having a meeting of the minds. If this court finds that the investigator's testimony does not rise to the level of establishing venue, then I think, and this court finds that counsel should have objected and was deficient for not, then I think you can establish prejudice.
Okay, I think that's where I was getting. And so thank you for the answer. I understand.
Yeah. Unless there are further questions on venue, I'll briefly move to this Brady claim. And the first thing I want to point out is that to the extent that there is an allegation of sort of malice or ill will on behalf of the prosecutor, there's nothing in the record that reflects that. My understanding of the record is that these were DCS reports that included this forensic or this evaluation, and that when the state responded that it did not have the reports, that it was because it was within the custody of DCS. So the state wasn't maliciously saying, "Oh, we've got it, and we're going to try and hide it," and doing anything like that. So I just
for Brady purposes, they're responsible for it.
So it is imputed. The state, I think the defendant or the petitioner has met two of the Brady prongs, says that he certainly requested it, and that the state, because that is attributed to the prosecuting office, the state did suppress it. I just wanted to be clear that there was no sort of malice or intent. And to the point that the petitioner alleges that there should be some skepticism here and cites the Auger case, the U.S. Supreme Court case, I would suggest that this court go and read that entire case. And a page later, after they talk about how that there's really no excuse, the Supreme Court reemphasized, as they did in Brady, that does not come into play. So even if this court were to think that the prosecutor was being sort of malicious or was intentionally hiding it, that does not come into play under Brady
I think
analysis.
my concern about the Brady claim is the materiality of the information. Could you address that, please?
Yes, Your Honor. And it's neither material nor exculpatory here because everything is
It doesn't have to be exculpatory. It just has to be material and
or favorable.
Right.
It's neither material nor favorable. And I think Judge Hickson pointed out that there's no proof in the record of what this would have, how the jury would have been able to interpret this. Even trial counsel testified that if I had this report, I would have liked to present it to the jury and didn't elaborate on why. And so we have nothing in the record to establish why this report would have been favorable.
So post-conviction counsel did not call a witness at the post-conviction hearing to say, if we had had this report, this would have been my testimony as an expert to the jury, for example?
That's correct. That there's no expert testimony that the lack of injury to the victim's hymen in any way corroborates or discredits.
The statute requires penetration no matter how slight.
Correct.
Okay.
But the petitioner is saying that he asked for a couple weeks for the express purpose of providing that testimony post-conviction denied. Post-conviction court denying relief relies partly upon the fact that there was no proof in the record establishing the significance of this exculpatory. Is that fair?
I think so, Your Honor, because the petitioner still had time, even after this continuance was denied, to do something, to present some sort of affidavit or report or something to establish both prejudice in the denial of the continuance and to establish prejudice under the Brady prongs or materiality under Brady, and he failed to do so. I think the record's more accurate, but my recollection is that there were about 2 months between the time of the hearing, and the motion for continuance was before that, and the time that the court entered its order. But certainly there was time to put something on the record.
Well, jumping back a point, I know I was prodding Mr. Harwell in one direction, prod you in another one. Jury hears this, common sense. Common's not broken. She's not right. She wasn't right. This didn't happen.
And I think that leads to that this court would have to speculate as to why a jury would even think that. I think, as you point out, that goes to sort of knowledge or to facts outside of the record, and it doesn't rely on their common sense. And as I think it's important to note that this report, this exam, took place months after this, and as the expert, the medical examiner stated in the report that this was all consistent with victim testimony, and that would have been before the jury. So to the extent that the jury was like, well, maybe this could have done something, instead they have the only expert that we have here saying this is fully consistent with the victim's testimony. And I think to Judge Greenholt's point, the statute requires penetration however slight. So even if they had said, well, it didn't go far enough in to cause injuries to the hymen, and that was a requirement, it was not material. It would not have changed the outcome of trial.
I mean, in fact, that's not a requirement of the law. The law does not require penetration to rupture the hymen. But what is important, and I think in my mind, and I want to hear you address this as your time is out now, here, it would be important here if the acts described by the victim were inconsistent with the hymen not being ruptured. So what I hear you saying is there was proof at trial that established that victim's testimony is consistent with the medical evidence. Can you help me with that a little more?
There was not proof at trial that it would have been. Had this report come in, then there would have been proof at trial that this was directly consistent with. The report itself says, I examined her, there were no injuries to the hymen, this is consistent with her testimony, with her allegations. I see my time is up. Unless this court has further questions, again, we ask this court to affirm the denial of post-conviction relief. Thank you.
Harwell.
I have two very brief points and two larger points. The first, I think I now understand what the state is saying as to venue. The state's argument today seems to be that because investigator Sakovich testified that he listened to the forensic interview, that when he was asked whether these events occurred in Knox County, and he said yes, he was meaning everything that he heard in the forensic interview took place in Knox County. I think that's simply not a logical reading of his testimony. If all that is saying is the child help interview took place in Knox County. The second quick point, I think the trial court was wrong, and I think that the state has repeated this. The report that's the subject of the Brady issue was in the prosecutor's file. At the post-conviction hearing, the prosecutor handed it to the judge. I never even was allowed to have it. The witness wasn't allowed to look at it, but that came from the prosecutor's file. So there's no issue of, oh, it was DCS, but that's an agency. It was in the prosecutor's file, unless he got it after trial, which the state certainly did not suggest at the hearing. Two bigger points, and this is repeating some things I've said before. This was a weak case in terms of delayed report. It was a weak case in terms of any corroboration. I mean, the state's corroboration was that the investigator watched the forensic interview, and the complainant cried during the forensic interview, and the mother said she seemed to have a change in her personality after making this allegation. That was their corroboration. It was her testimony and virtually no corroboration. Defense established there were a lot of reasons to doubt her testimony. She described a setting of 2 beds being in a room that hadn't been that way for a number of years. So this is why the jury obviously had doubts as to what happened. The point that I think I'm just trying to drive home by saying it over and over again, louder and louder, is this is absolutely blockbuster evidence, this 412 stuff. This is what a defense attorney would be praying to have to use in a trial of this nature, because otherwise what he had to do is he had to make the argument of, well, she's lying because she didn't get to go to Disney World, or she's mad about a new baby in the family. Arguments that on their face, it didn't make any sense. The Disney World trip was later anyway. He had to answer that question. He got to trial. He had no effective answer. He tried because he knew he had to do something. But it was a blockbuster, not just, again, don't just take my word for it. This is one of the best trial attorneys in Knox County, and he thought it was a blockbuster. He said at post-conviction, this is how I would have presented this. We are here because of Tyler. This was her motivation to lie.
Why didn't he do that then? The state was saying in the opening statement at trial, if he just assumed that it was coming in, why wouldn't he stand up and say, ladies and gentlemen of the jury, let me tell you why this little girl is saying this?
Well, the opening statement, and I just looked, it's a very short opening statement in terms of, he says, you're going to hear this, it's going to sound credible, and we're going to explore why it's not credible, and you're going to, make a decision at the end of the proof. He's holding this back. And he says that this is his plan, that he would have made this closing argument at one point in post-conviction. He maybe exaggerates, but he said, I would have spun it out for 30 minutes. Right? This is something that you're praying for in any case. And here you have a case that is so close that it almost halfway went your way anyway. This was blockbuster. And it ties into, I think, the main issue this court is deciding, which is, can call it cumulative error or just the individual issues of Brady and Strickland says, let's look back at the trial. Let's look at what should have happened that didn't happen and say not preponderance of the evidence, would the outcome have been the same, but would this have put the case in a different light, such as to undermine our confidence in the jury's verdict? Had 412 information come out, had a basis of knowledge, reason to lie, a direct contradiction with her testimony she lived with her mother throughout, had the hymen being intact come out, this would have been an entirely different trial. And I think that's what Mr. Cooper is entitled to. We're not asking for him to be declared innocent. We're asking for him to get the trial that he was entitled to get the first time. Beyond that, I'll rest on my briefs.
Thank you to both counsel for your arguments here today. Very well done. Recess for about 10 minutes.
All rise.